Good afternoon, everyone, and thank you for joining us at today's webinar on the UAE data protection law. This is the last webinar in the series of New Year's update webinars we held this week. Stuart Walker and Mohammad Nawash will lead the webinar and discussion. Stuart and Mo will run through the slides first, and we will save the Q&A session till after the slide presentation. Kindly submit your questions throughout the webinar in the Q&A box. Please submit them in the Q&A box and not in the chat box. We will attempt to, we'll make every effort to wrap up the webinar in 30 or 45-minute stops. And to the extent that we do not answer everyone's questions, we will address them offline. You'll be able to contact the speakers directly for any additional queries or any information that you would like that were not addressed during the webinar. Without any further ado, I will pass it to Stuart and to Mo.
Great, thank you very much, Samira. Good afternoon, everyone. My name is Stuart Walker. I'm a partner with Afridi Angell here in Dubai. Afridi Angell, as hopefully most of the attendees know, is a law firm here in the United Arab Emirates. We've been here 40+ years. I came out from London to join the team back in 2003, and so I've been practicing here in the UAE for close to 20 years now, I suppose. Like most of my partners, I have a sort of diverse practice, essentially a corporate commercial practice, which focuses on, in my case, financial services regulation and DIFC matters. The very exciting thing about the UAE, obviously, is that we're a young country with new laws coming into force all the time, and these data protection laws are just the latest example of some of the new legislation that's coming into place. So as Samira has suggested, we've got about 30 to 40 minutes to talk about this afternoon. But if you have something else to get to, I'll cut to the chase. There is some good news about the new law, and there is some bad news. And the high-level summary, the good news is that if you're familiar with data protection issues from other jurisdictions, the concepts that have been introduced in the UAE are very, very similar. There are no real surprises in terms of the structure of the way the regulations, the legislation has been organized. So that's the good news. The bad news is that it is another layer of local regulation. It's not simply a case that if you already comply with your data protection obligations in your home jurisdiction, you're okay. If you have an office or any sort of presence here in the UAE, you're also going to have to comply with the UAE's legislation. Despite it being very similar to what you're going to be familiar with in other places, you also have to comply with this. So that's a little bit about myself. I'm going to hand over to my colleague Mo to introduce himself, and then really get into some of the key concepts in the legislation, and then we'll come back to myself for a little bit of a chat on some of the slightly more problematic issues generally with the legislation. So over to you, Mo.
Thanks, Stuart. Well, I haven't been around since Stuart has, but I've only joined Afridi Angell about a year ago. Prior to joining Afridi Angell, I was an in-house lawyer for a company in Cambridge, well, a tech company. And my practice at Afridi Angell, I've been predominantly M&A and restructuring, but I also do a lot of data protection, where I advise clients on the data protection implication to introducing new technologies in the UAE. Samir, if you move on to next slide, please. Yeah. So if we firstly take a step back and start looking at the UAE's data protection framework prior to January of this year, and prior to the issuance of Federal Law 45 of 2021, we all know that the UAE has not had a standalone sector-wide data protection law, and data protection regulations in the UAE very much consisted of patchwork of limited provisions from the UAE's penal code, constitution, and cyber crimes law. The laws were not as detailed and sophisticated as those issued in the free zones like the DIFC and ADGM. So that's another reason for the another reason for the introduction of this new data protection law is coupled with the strategic focus on data and technology in the UAE and the global privacy and cybersecurity concerns which currently up the international agenda. So for us, it didn't come as a surprise that such reform was required to be made here for basically a more granular sector-wide data protection legislation. Now, if we talk about as to whom this UAE personal data protection law apply to, well, it'll apply to firstly an individual who resides or has a place of business in the UAE. Secondly, any business in the UAE which processes personal data of individuals, whether those individuals are located inside or outside the UAE. And thirdly, any business located outside the UAE that processes personal data of individuals who are located inside the country. So this would be your standard international service provider, could be based out of Luxembourg, providing X or Y services to UAE customers or UAE clients. So from that, it could be understood that, well, this data protection law has an extraterritorial effect. So again, that's the bad news that Stuart was talking about earlier, which apply to businesses that do not have a presence in the UAE, but who service customers, clients, or even business in the UAE. Now, moving on to my third point of this slide, there are several similarities, which is the good news, which exists between this newly enacted UAE personal data protection law and laws of GDPR, ADGM, or DIFC. And one of the similarities is the way personal data is defined. So personal data under this new law is defined as any data relating to an identified natural person or a natural person who can be identified directly or indirectly by way of linking data using identifiers such as name, voice, picture, ID number, any other online identifiers or special features that express the physical, psychological, economic, cultural, or social identity of that person. The definition of personal data also includes, like GDPR, like the DIFC, sensitive data and biometric data, which is quite a new concept for an onshore law. But it is explained very broadly as any data that directly or indirectly reveals a natural person's family, racial origin, political or philosophical opinions, things like religious beliefs, criminal records, biometric data, or any data related to the health of such persons. So it could be a physical, psychological, mental, genetic, or even sexual condition. Samira, next slide, please. Now, moving on from the key concepts, there are overarching principles and requirements which are recognized under GDPR and which have also been incorporated into this UAE data protection law. The first one is fairness, transparency, and lawfulness. And this means that personal data must be processed in a fair, transparent, and lawful manner. Purpose limitation provides that personal data must be collected for a specific and clear purpose and is not to be processed in a manner which is incompatible with such purpose, the purpose the data was collected for. Data minimization prescribes that personal data collected or processed by a business must be limited to what is needed for the purpose for which it was collected. And Stuart will be discussing what processing versus collection or collecting of data means in later slides. Accuracy, here we are talking about data, that data must be accurate, correct, and updated whenever necessary. And here we would expect our clients to put in place appropriate measures and policies to ensure the erasure or correction of incorrect personal data held of data subjects. Security and confidentiality, that's quite straightforward. All personal data, the law prescribes that all personal data must be kept secure and protected by appropriate technical and organizational measures and procedures. And storage limitation in this context means that personal data may not be kept stored at your company or at your business of those data subjects after fulfilling the purpose of processing, unless the identity of the individual is anonymized. So we kind of get these requests all the time from clients where you can continue to store data if that data is anonymized and does not link to certain personnel. Finally, consent is a big topic, and consent must be freely given under this data protection law. It has to be specific, it has to be informed and unambiguous. Now, there are exceptions apply where you can process personal data without obtaining consent, and these exceptions include protecting the public interest, defending a certain legal claim, protecting the interests of individuals in question, or fulfilling an obligation under UAE law. Samara, next slide, please. In this slide, we will be discussing the arrangements you should be doing to comply with this data protection law. So the overall objective should be to adopt arrangements to secure individuals' rights through appropriate policies, procedures, or measures which can be put in place to secure various rights to individuals. And such arrangements could include, firstly, the right to obtain information. So here, individuals have the right to be told about what aspects of and how their personal data is being processed. And so the use of such privacy notices, and by privacy notices, I mean sending out notices to data subjects, informing them about the data you hold about them. So I was living in the UK at the time GDPR took effect, and I think I received about 30 or 40 emails from companies issuing privacy notices telling me that they hold my information, how they were using my information, and how I could request my information to be removed. So I would suspect that when this data protection law comes into effect, we will be getting these privacy notices. Right of access, you should have policies which enable mechanisms for individuals to have right to obtain access to their personal data, as well as be able to update it, correct it, or request for it to be erased. Right to restrict or stop processing. Also here, this data protection law powers individuals to allow them to request for their data or to request from processors to stop processing their personal data and delete it. So if a particular data subject replies to a privacy notice saying, "Oh, I didn't know you guys were storing my personal information, but I want my personal information to be deleted," you've got to comply with that. Because they also have the right to file, and you should also allow a mechanism where there's a right to file a complaint. So in your data protection policies, you should have a statement which says along the lines of, if you have any complaint, you can contact this person at this email address. And this person will usually be your data protection officer or a legal counsel who is responsible for privacy and confidentiality. Right to withdraw consent. Here, individuals have the right to withdraw their consent they have given regarding the processing of their personal data. Data security and breaches. Stuart will be discussing this in more details in later slides, but essentially under the new law for data security and breaches, businesses are required to notify a body called UAE Data Office. Now we don't yet know much about this UAE Data Office, but we would expect this to be an office which will administer and uphold the law of this, which will uphold the data protection law. And you should also notify those individuals who are affected if a personal data breach does occur, and only if this breach kind of does prejudice the privacy and the security of personal data. Data protection officer. So now there's a requirement to have an arrangement in place to appoint a data protection officer. And that data protection officer is, by the way, not required to be based in the UAE. So you could have a data protection officer based in the UK, in the US, or whatever, or basically anywhere outside the UAE. But the requirement to have a data protection officer is usually triggered if the processing is likely to involve a high level of risk, first of all, to the privacy of personal data, or you're using sensitive technology, or you're kind of processing a great volume of data. In those instances, you would be required to have a data protection officer. And finally, for data protection impact assessments, businesses would be encouraged to carry out an assessment and explain to the UAE data office as to how they process personal data and what safeguards are available which apply to their processing. So safeguards can include maintaining a special record of personal data, who accesses this personal data, and whether there are any processing or arrangements which could basically lead to a cross-border data transfer, whether there are any arrangements in place for cross-border data transfers. And Stuart will be discussing this in more detail. So thank you for listening. I'll hand over the next slide to Stuart.
Oh, thank you very much for that. That is an excellent intro to the main topics that are contained in the legislation. What I'm going to do now is just talk to the four subjects which are up on the slide in front of us, and just talk about some of the sort of practical issues that the attendees, who I'm assuming are in-house counsel or compliance professionals at different organizations, will have to think about in terms of really sort of practical things to worry about, be concerned about, or to speak to their colleagues about. So on cross-border transfers, the legislation says that you can only, if you're processing data in the UAE, within the state, you can only send it outside the state if you meet certain conditions. So this is going to be relevant to pretty much every organization, apart from a purely local business that only has local customers or clients and only ever deals with other counterparties or suppliers in the UAE. Everyone else is going to have issues to do with cross-border transfers. If you're part of an international group, if you outsource any of your functions, if you have suppliers outside the country, or even in fact within some of the free zones within the UAE, you're going to have to think about the cross-border transfers that you're engaged in and the restrictions that apply thereon. The key issue is that you can only transfer data when there are adequate protections in place. So you have to assess whether there are adequate protections, and more importantly, from an audit perspective, there should be a record-keeping process to show that you've looked at all the different cross-border transfers, that you've considered the different jurisdictions, and that you've satisfied yourself as to the adequacy of the data protection regimes in those other jurisdictions. In practice, this is quite a complicated task and something that needs to be reviewed again and again and again, unfortunately. So that's cross-border transfers. Turning to controller versus processor. If you look at the law and if you look at other data protection regimes, there is a key distinction made between data controllers and data processors. And if you just read the black letter law, they actually sound quite similar. So, but the obligations, the requirements between the two are different. In summary, controllers are subject to more obligations than processors. So you need to ask yourself, in respect to each different data subject and the data that you hold for different subjects, am I acting as a controller or am I acting as a processor? Because your systems and controls around the data will need to be different depending on whether you feel that you are one or the other. Perhaps by way of example, if I am a bank, for example, and gather information about my customers and decide that I want to use information about their typical spending patterns to design an advertising campaign, I'm almost certainly at that point a data controller making decisions about the personal information and data that I gather about my customers. I might then, as the bank, provide some of that information to an external marketing company or an advertising company to help me design an advertising campaign. And I may give that third party, the advertising company, I might give them a lot of the personal information about my customers and say, please, put together a mail shot or some sort of email campaign dealing with all these customers. That third-party advertising company is now processing the personal data that I gathered about my customers. So they'll be a data processor, but not necessarily a data controller. So as I say, the legislation is pretty clear that there are different obligations. There are more onerous obligations for controllers and processors, and you need to be clear when deciding what what your obligations are, whether you're one or the other. Turning to data breaches, this in a perfect world this would not happen, but in reality it does happen, either deliberately or accidentally. You hold a lot of information about your customers or your patients or your clients, and somehow that information is leaked, either because you've been hacked or because there's been an accidental breach of your systems. You then, as the person in charge of data protection within your organization, you have to decide what to do when you're told that there has been a breach. Obviously, in practical terms, the first thing you want to do is work with your IT colleagues to stop the breach, to make sure that you're not losing any more information, and that you do whatever you can to sort of claw back any data that's leaked. So that's a practical first step in terms of just controlling the breach. But then thereafter you have reporting obligations to the regulator. You may need to notify the data subjects, and then where you might want to reach out to your friendly local law firm, you have to decide, you have to start doing the analysis around the liability that the organization faces as a result of the breach. Now, you may have a problem with the regulator. They may impose fines if you've failed to have adequate protections in place that has allowed the breach. You may be subject to regulatory action by the regulator. So you'll want to prepare and get ready your defenses to deal with that regulatory investigation. It's important, as with dealing with any regulator, that you don't start destroying or hiding information at that point, because that could create an even bigger problem with the regulator. So one work stream is going to be, in terms of the data breach, is going to be preparing and getting ready for the engagement with the regulator. The other work stream, where again you may need assistance from lawyers, is potential claims from your data subjects, your customers whose personal information has been leaked or lost as a result of your failure to properly secure the information. They may want to bring some sort of action against you if they have lost, if they've been subject to some sort of loss or liability. So, yeah, two things to think. Well, several things to think about in terms of breaches. Stop the breach. What are you going to say to the regulator, and what are you going to say to the data subjects whose information has been exposed? Then the final point, which I want to talk about, is the what in other jurisdictions is sometimes called a subject access request. Those are words that you will not see in the UAE data protection legislation. But what this is a request from a data subject to review the personal data that you hold about them, and they have the right to request that incorrect information is remedied or rectified. How this works in practice, how we use it in our practice for our clients, is as a tool in disputes. Where there's litigation or threatened litigation, one way of exerting pressure on the other side is to start bombarding them with these sort of data protection requests, because normally in litigation there's a timetable for disclosing information. You can get extra information, you can put more pressure on the other side by making use of the data protection legislation. That wasn't what the data protection was created for, but that's the way it gets used in practice by disputes lawyers who are aware that they can use this as a tool to put pressure on an organization. So what this might mean to you as the professional within the organization responsible for compliance or data protection specifically, if you suddenly start to get data subject requests or requests for rectification of your personal data, that may be a sign that someone's about to sue you, or is considering litigation of some sort against the organization. It's something to be very mindful of. And in reality, depending on the type of business you are, it may actually be the main area where you have to deal with the data protection legislation in terms of external inputs from other people, third-party requests, etc. So that is the sort of the four big picture points that I wanted to just highlight as practical points. If we just go to the next slide, please, Samara, I'll just finish off with a couple of points on timelines. As I'm sure you know, the UAE legislation came into force earlier this month, at the beginning of this year. The executive regulations are to be issued within the first 6 months, so latest by 2nd of July. And really that's where the nitty-gritty details are. The principal legislation leaves quite a lot of scope for detail to come in the executive regulations. So I know we've got quite a few questions coming in on the chat. We will attempt to answer some of those, but the answer to a lot of that is until we see the executive regulations, we will not know for certain. The law says that organizations have a grace period of 6 months after the executive regulations to sort of get fully in compliance. So it could be until this time next year at the latest that you really have to be fully in compliant with the legislation. But I would not leave it that long to start thinking about this. You need to be getting your organization in compliance and thinking about the processes, particularly the cross-border analysis, well before the grace period ends. And my final point before closing, because we we've run over the half hour I wanted to keep to. My final point is really just the sort of consideration of our expectations around how this legislation will be enforced within the United Arab Emirates. Historically, people that have been living and working in the UAE for any length of time, there's been a pretty relaxed approach to personal data. You know, if you have a bank account here or if you own property here, you will have been contacted by any number of financial advisors or mortgage companies or real estate agents offering to buy your property or sell you more property. You know, people's personal data is freely shared in the UAE, or has been up until now. So that sort of laissez-faire approach has to be balanced against the fact that this is a socially conservative Muslim country where personal information is you know, subject to quite strong cultural norms about privacy. So there's a bit of a tension there between the historic approach and maybe some cultural considerations, and that, you know, matches some of the international approaches. We have what might be called the sort of US tech giant Google/Facebook approach to data protection, where they feel that data should be harvested and mined and put to commercial use by organizations, and perhaps they would prefer more relaxed data protection regimes, balanced against what is developing as the European approach, which is more regulated, more controlled, more restricted. So internationally, there is a bit of tension between the US approach and some of the other countries, and here locally we have a tension between the historic basis and some of the potential cultural considerations. The reality is that we don't know until the UAE regulator really gets going and really makes some decisions and takes some enforcement actions. We don't know which way they will swing. But best advice at this stage is to assume that the regulator will use its powers and could impose fines and sanctions, and people should not be relaxed about this issue. They should make sure that they're doing what's necessary to become compliant with the legislation. That is what I wanted to say. Thank you for listening.
Thank you. Yeah, thank you, Stuart. Do you want to go ahead and address some questions, or you want me to, would you?
Yeah, we have several questions on the screen now, Stuart.
Yeah, okay. Just taking the first couple. There's a question: are there English translations of the law? There are various English translations made available through different law databases and subscription services. I think your ability to access them will depend on what you've subscribed to. But you know, if we're instructed in particular matters by clients, you know, we're more than happy to provide copies of what we have. There's a question about vaccination status of PCR tests, medical tests, and whether that would be considered personal data. The one thing to be aware of is that there are specific laws in the UAE around health data, which, you know, you have to think about in conjunction with the general data protection law. But as a broad concept, then yes, you know, if a medical organization is collecting information about PCR sort of vaccination status, that is certainly personal data. It could even be sensitive data, and yes, yeah, that is controlled, of course. Yeah, all the data protection legislation will apply there. No, I don't know if you wanted to take.
Yeah, no, I very much agree, and also not just health data, but the new data protection law defines biometric data as a very broad description. So even religious beliefs, things like criminal records, political opinions, race, that all is personal data. So I would suspect that a vaccination status would also fall under that.
There's an interesting question concerning money laundering, essentially, and whether the new law restricts financial businesses from making suspicious transaction reports. You know, the answer to that is no. If you think there's a money laundering issue, you have to make a report of that. You can't just say, oh, that would be a breach of the data protection law. I'm not going to mention the fact that I think this client is engaged in money laundering. The tension between different pieces of legislation is something that we wrestle with all the time. But I don't think that it would be wise to think that you could hide behind the data protection law to avoid complying with anti-money laundering legislation.
And I think disclosure is also permitted where it's in the public interest, and you could argue that this would be in the public interest for you to report any criminal money laundering activity. So disclosure would not breach the rules here.
Yeah. Okay, Mo, thank you very much for that. To all the attendees, thank you for your time late on a Thursday afternoon. I know this is a slightly dry subject. It is an area that is, you know, just becoming part of practice in this part of the world, in the same way as it is in many other countries and jurisdictions. You're probably already familiar with it if you're part of a multinational organization. Here at Afridi Angell, we are working with international clients to help them map their international policies into what their new policies will be here for the UAE. I know we haven't had a chance to answer every one of the questions that have come through on the chat. We will endeavour to follow up with people individually after this. We will circulate these slides to attendees. Mo's details are there. My details are there. Please reach out to us if you'd like to talk about this in any way. More than happy to provide more detail as necessary. And thank you very much for your time this afternoon.
Thank you.
Thank you, Stuart. Thank you, Mo. And thank you, everyone, for joining us this afternoon. As Stuart said, we will share the slides and we will also share the recording with you. And please feel free to reach out to either Stuart or Mo for any additional information. Thank you and have a great evening.